So many of you I've either worked with individually, or a couple of you I've worked with as a group. Adrian, I've worked with him in the past. We also worked together on the IEA product and a couple of other products with April King, who is a longtime member with the group as well. So to kind of get things going, I want to talk about intellectual property as a total package. So when we talk about IP, we're not just talking about patents, and of course the three different components of patents or types of patents, but we're also talking about copyrights, trademarks, your trade secrets. And the reason it's important to think about things as a whole is because when it comes to licensing your technology, you're not necessarily going to license just one part. You're going to license all parts, provided all parts are part of your portfolio. And in fact, they very much likely should be. Part of that depends on how far along you are in the process, but in general, at least most of these parts should be part of your intellectual property portfolio. As you're aware, patents, there are basically three types of patents. Two of those are more likely what you will come in contact with as inventors, which are utility patents and design patents. Copyrights are related to all of those other elements, documentation, drawings, websites, packaging, materials, software that may be part of your intellectual property portfolio, as well as those trademarks, which are very important and contribute overall to the goodwill that's associated with your brand, your product, and you. And then there are those trade secrets, which are those unpublished parts of your intellectual property, those things that you hold basically near and dear, that are not published, that you take great care and concern to protect those so that you can gain and continue to gain and maintain your competitive advantage in the marketplace. What I want you to do is think about how each of these things as a whole contribute to your entire intellectual property portfolio. Because again, it's not going to be one, it's not going to be two, it should be a combination of all of them in a whole package. When you do that, when you think about the difference, and when you think about licensing, what I want you to consider first and foremost is the difference between assigning your intellectual property versus licensing your intellectual property, and there are significant differences to both. Licensing in general is the way that most companies and most individuals go in the direction of when it comes to their intellectual property. Assignment is rare. It's usually on a corporate-to-corporate basis, and because in an assignment provision or assignment situation, you are basically, it's like selling your house. You've moved out, the keys are gone, and you don't get to go back in. So you're signing all of your intellectual property rights, particularly to your patents, forever. There are some cases where you may be able to go back and reclaim some of the royalties associated with your intellectual property, but those obligations and rights and opportunities to long-term gain revenue from your from an assignment deal could be inhibited or could be in jeopardy if there's a bankruptcy based on the person that you've assigned your license, your intellectual property to through an assignment. In order to be valid, an assignment has to be recorded. It has to be on record, much like the sale of a home. If it is not valid, and it is not recognized by the U.S. Trademark Office. Licensing, however, on the other hand, is generally the direction that you want to go, because at this point you're licensing on a temporary basis your rights to that intellectual property. How you grant it, how long you grant it, and all those other key things to think about we're going to talk about in a moment. But those permissions, those licenses, those grants are limited. You can choose to license all of them, some of them, and in certain cases, how you carve those out can be very important in order for you to maximize and exploit all of your licensing opportunities. However, there are some pitfalls there, because if you don't take the time and care to do it properly, you may lose some key advantages there, and we're going to talk about that briefly. So some key terms and key things to think about when you want to start thinking about, I want to license my intellectual property. A couple things I want you to think about are here. These are things that are actually going to end up in your license agreement. So these are absolutely things you need to know. Licensing isn't a one-size-fits-all. You really need to understand your product, its place in the market, its market opportunities, the licensor, the person that you're going to license it to, how they're going to maximize it, where it fits into their product portfolio if they already have one. And so these are all things that you're going to need to do as part of your homework in determining how you're going to license your intellectual property. So I've listed a couple of key things here, non-exclusive versus exclusive, and those are related to the type of grant. The field or field of use is related to where or how they are going to use your intellectual property. Payment requirements and considerations, what do you get out of this? What is the benefit to you? And of course, the benefit for licensing your intellectual property is so you get paid. And I think that's the road a lot of you want to take in licensing. Rather than go through the whole process yourself from concept to commercialization, you want somebody else to do some of that work for you. In exchange, you'd like to take a little bit of a setback and just gain some money off of that deal. The term and duration are also limited by the scope of the license agreement, as well as some other things like audit requirements, what opportunities you get to retain while you've licensed your intellectual property, continuing rights to improvements and ownership, even if there's some litigation, who's going to defend those rights and who's going to enforce them. And then there's some sub-licensing. And then, interestingly enough, the day that you go into a license agreement, I know it's hard to think about, but you also need to think about what happens on that day when it comes that I need to get out of that licensing deal. So you need to be able to think in advance. It's not a reactive response to this licensing deal is not working well, I'm not getting paid, they're not doing what they said they were going to do. You kind of need to put some forethought into how do I get out of this if things don't go well. And even in the case where things are going well, how do I get out? Because again, this is a limited term duration. So even if things are going well, you still have to have an exit plan. So I want you to think about those things at the onset rather than be reactive. When I talk about non-exclusive versus exclusive, I want you to note one key thing here. Non-exclusive on my list is first, exclusive is second. Could anyone tell me why I put them in that order? Exactly. Non-exclusive gives you greater flexibility, the ability to fully exploit your intellectual property. It's basically not putting all your eggs in one basket, essentially. Exclusive limits you. When you license someone on an exclusive basis, and there are other ways to do this where, in a sense, you could be doing a combination of both, those rights are sold to that individual or that company. So if they aren't doing what you want them to do, or if they miss their milestones, or things just aren't working out, in addition to getting out, you've missed that whole time in which you're not realizing the benefits of your intellectual property. So if these guys aren't getting things to manufacture, or if they're not getting things to commercialization, or if they're not marketing like you intended, where are you making your money? There are carve-outs in the agreement that you can put so that you get some minimum payment no matter what happens. But are you looking for minimums? You want maximum. You want to maximize your opportunities. So when you look at things on a non-exclusive basis, you're giving yourself as much opportunity to do that as possible, rather than on an exclusive basis. Also, and we'll talk about this a little bit more, you only want to license someone access to your intellectual property to exploit it where they can actually do that, where they can actually benefit you. So if you're not going to license someone on a worldwide basis if they don't have a worldwide presence, right? You're not going to license someone to do business in South America or Europe. One, if you don't have those protections there, but two, if you don't have potential market opportunity there. So think about Who, what, when, where, and how. Those are kind of part of the deals, but exclusive and non-exclusive are two of the initial core critical terms to understand up front. Then we talk about field of use or scope. So when you talk about, and I want you to think about your product, one of the things I want you to think about is all of the possibilities that you have related to your product. Are there add-on or accessory components, or can it be a commercial product versus a consumer product? Are there different classifications or different uses? I can give you an example of this. As one of my 100 other things that I do when I'm not sleeping is I'm a practicing metalsmith. One of the things I learned real quick is to not go to my jewelry supplier catalog to look for these very expensive tools, but to go to the Ace Hardware and the Lowe's and Home Depot, and I find some of the same tools that in my supply catalog I would pay up to $100 for that I have found at Harbor Freight, for example, for $5. It's incredible, and let me tell you, we spread that word very fast because with the price of gold and silver, we can't afford to buy $100 hammers all the time. So the reason I bring this up is because when you think about your product, I want you to think about not blindly, not what is the one place that you've concentrated solely on where you think that you might be able to take this to market, but think about other areas, think about other uses, think about other ways that you can bundle it, other applications. Consider geographic limitations that you might have versus the licensor, the person that you're investigating to be your partner in your licensing deal, and the class of products. Think about how, again, to maximize your intellectual property so that you can ensure that the person or persons that you're going to enter a licensing deals with can actually maximize all of those opportunities. Does that make sense? Then once you get into a deal, you figured out what you've got, where you can license it, who your partner is going to be. There are a lot of other things to consider, and the biggest one, I think, for all of us is how to get paid. There are a lot of ways to carve that up, and there are a lot of ways to consider how much that payment comes out to be on a short-term, long-term, or over the term of the contract. You can get paid up front. You can take a one-time, walk away, pay me, I'm good to go. Not generally recommended. Doesn't give you maximization of your intellectual property portfolio, but some people choose to do it. It's not an assignment because you have the right to take it back. However, it's just that one time, big money in my pocket, and I get to go walk away from this for a little while, with some exceptions. There are also considerations for where you are in the process. You might have your patent. You might have your patent only in a provisional status, or you might be in the situation where you want to take it into other areas. You might want to negotiate with your licensor some assistance in your patent prosecution. You might want to consider some assistance in granting them a portion for commercialization, for manufacturing, for marketing. You might do these carve-outs for them in terms of your payment plans. There are royalty-based, where you will get a periodic fee over the life of the license agreement. So every month, every quarter, every year, whatever you deem, you can set that up. Most generally, they're royalty-based, and then they're based on one of two things: dollars or volume. And there are key differences there that you need to think about. Volume-based is generally the easiest because you sell it or you don't. On those units that are sold, when those units are sold, you get paid based on that unit. And you can say it's $5, it's 7%, it's 12%, it's whatever you work out as part of your license agreement. But it's based on the physical unit, if you will, if you're talking about a tangible product being sold. When you talk about dollars, based on dollars, what you're now battling with is whose dollars and how those dollars are calculated, whether based on gross revenues, net revenues, what you've done to address chargebacks and payments, how do you address customer satisfaction, how do you address discounting, how do you address bundling. You need to think about these things. When you talk to your prospective licensor and you look at how they sell their products, you're going to get a good idea of how they handle these things today. You're going to get a good idea if they have products where they sell them as a single, a standalone, a bundle, a multi-pack, those kinds of things. You're going to understand if they sell both in the commercial or consumer space, if they offer tiered discounts. So maybe somebody comes along and they buy one, they're going to sell it at a certain price. If they buy 5, they'll sell it at a discounted price. If they sell up to 100, they'll sell it at a discounted price. Those discounts cut into your sales, your revenue opportunities. So you really need to understand how those may impact your bottom line in addition to theirs. Currency is a big thing that gets overlooked. You would be surprised how people enter into license agreements based on regions and don't put US dollars in there. Think about the cost to convert dollars, right? Big difference between US dollars and European dollars and other currencies. Make sure that that is built in because you don't want to take that hit. You also don't want to get a check that now you're going to have to go to the bank and say, what am I going to do with this? And you take that currency conversion hit there as well.
Make sure it's not dollars.
Yeah. You can deposit to the Cayman Islands if that's what you put in your agreement. And one thing you absolutely want to do is make sure that you have some minimum baselines, that no matter what happens, you get some form of minimum payment. Again, I don't think any of us are striving to work for minimum wage, nor should we strive to work for a minimum royalty payment, but at least you have a baseline for something that you can basically guarantee against, right? Because if someone's only meeting their minimums, there might be a problem. Because again, what are we trying to do? Maximize, not minimize. You also want to consider milestones. How long is this going to take to get to market? What are all the things that need to be done? How long is marketing going to take? How much is that marketing going to take? How long is it going to take to commercialize? What are the manufacturing streams and what is the manufacturing process? You decided to take the licensing route because you didn't want to do this yourself. But that doesn't mean you don't own some accountability and responsibility for ensuring that those things happen, okay? Simply because the licensing partner is going to do those things, you want to make sure that those things actually get done, and they get done when they say they're going to get done, obviously within some milestone reasons. But you want to make sure that those are in there because potentially you might take a milestone adjustment on your payment. You may actually make a penalty payment as part of a missed milestone. Because again, if those products aren't out there selling, are you making money? And that's the goal, right? To make the money off of those royalty considerations. Back to time and duration. So you want to think about not only the product life, but you want to think about is the licensor. Is this someone that's been in business a long time? Is this someone that's also starting out in a particular market? Basically, is this going to be a test period? Is this going to be a long-term period? You want to consider market considerations also as part of your time and duration. And you want to consider how long that's going to take. Some time to market cycles are very long. So if your time to market cycle is 1.5 years, are you going to sign a 2-year licensing deal? No. You want to make sure that you've given ample consideration for allowing them time to perform to the contract and giving you an opportunity to realize whether or not they're the best licensing partner for you. But entering into extremely long-term licensing deals without opportunities to reevaluate those deals aren't necessarily the good thing either. Again, partner consideration is a big piece of that. In doing so, you want to build in some audit requirements. Are they doing what they said they were going to do? Are they making the payments on time? Are they meeting those milestones? Are they selling at the volumes they said they could sell? People are going to make commitments. I can move 10,000 a month. this month, and I bet you once I've ramped up, I can get to 100,000. Can they? Did they? If not, they're not meeting their commitments to you, and again, they're not maximizing your intellectual property, therefore not maximizing your revenue opportunity as a result. Are they meeting their other performance objectives? There may be other considerations that you want to put in and build those in. And again, it's not an approach to smack them around and say, hey, you're not getting things done. It's to keep tabs, because again, simply because they're doing the work doesn't relieve you of the responsibility to manage that. Yes?
You had mentioned that you can get out of the license.
Uh-huh.
And one of the ways to say, based off the performance, is that one of the ways you can say, look, you said you were going to move 10,000 units per month. You're not doing that. Is that one way to pull out of the license?
It is. There are steps to go. It's not you didn't meet your milestone, you're out this month. There are steps that have to be taken, but yes, that is one. Costs and penalties, another way to approach it is just simply say, you didn't meet your milestone. If you don't meet your milestone within 6 weeks, then I'm going to add a royalty or a penalty payment of X%. So it gives them a chance to try to catch up and step up and meet the requirements without being completely out of it. Because remember, even though you want them to do the best job possible, things happen. You don't want to beat them up, but you don't want to be beaten up. So you want to give yourself and them opportunity to try to make certain things right. Certain things may not be acceptable and are really deal breakers, and you have no choice but to get out, given your remedies. But you really want to make sure that you give opportunities for corrections too. And costs and penalty differences and variances are a way to do that as well. When I talked about the non-exclusive, that also gives you some rights. Because if you've done a good job of identifying the field of use, the scope, the duration, what it is, how they're going to license it, where they're going to license it, you get to retain some rights that you can now either go exploit yourself or go license with somebody else. You can take that same intellectual property and go licensing in a completely different region for a completely different market. Maybe you have something that can be used in the medical field that can also translate into another field. Maybe it's in a commercial space, but you can use it in consumer space. There are different ways in which you get to retain those rights so that you can then go and look at your opportunities elsewhere, provided you didn't grant all of those rights to that one licensor. You also have to consider the other rights that go along and the other rights and responsibilities that go along with intellectual property. So improvements. So how many of you have an idea or have patented something that's never ever been done before? Never ever been done before. There's nothing on the market like it. And how many of you have seen something and go, you know what, I can do better. I have a better way of doing it. All right? That's generally where the ideas are at least sparked from. Those are basically considerations that you have to think about when you look at your intellectual property. You may think you've got the greatest, the best possible way of doing it, but someone else is going to come along and think of another way to tweak it, modify it, basically improve it. You want to make sure that you, through your licensing right, retain some improvement opportunities, because your licensor, through their manufacturing, through their deals, through their workings, may come up with some improvements that you want to make sure that you capture so you can restart or continue that maximization cycle. Again, retaining ownership to your intellectual property is the key way to do that. Then there are defense and there's enforcement. You know, once you've got your patent, that doesn't mean you're home free. You have to make sure that you're defending your intellectual property. So if somebody out there is infringing, that there needs to be a process by which that patent is defended. You've got to go after those individuals and prove that they're infringing and follow that process. The responsibility for taking that enforcement and that defense needs to be written into the agreement. Generally, that would stay with you. But you may work something out where that gets transferred to the licensor and you work together and collaborate on the defense. But you need to carve that out, because Patent defense and enforcement is a great expense, and it's not something to be put on the back burner and think that I'm never going to have to worry about that, because everybody at some point, at some time, is probably going to have to worry about protecting and defending their intellectual property. Now, sub-licensing. How many people know what sub-licensing is? I got some smart cookies in here. You put your hand down. So when we talk about patents and we talk about licensing, there are a bunch of terms: make, have made, use, offer for sale, sale, resell, distribute, promote. All of those things are individual license grants. Now, how many of you have considered taking a product from concept to creation 100% by yourself? No help from anybody else, no manufacturers, nothing else. You're going to do every step all of your own. I see maybe one hand in the room. Yeah. Because the reality is you're not going to do it all on your own. You're going to have suppliers. You're going to have subcontractors. Those things need to be contemplated in the agreement. You don't want to do that on a sub-licensing basis necessarily, again, depending on the deal. But there may be cases in which you may have to look to a subcontractor. In that case, you only want to give them only the rights that are needed for them to do explicitly what they need to do that job for you or for the licensor. Okay? You don't want to over-sub-license, and you don't want to grant your licensor, the person that you've partnered with, the rights for them to just simply go sub-license. That puts you too far removed. It puts your intellectual property at risk, and you want to be very careful if somebody approaches you and asks you, I would like to sub-license. Warning flags and bells should go off, and you should have a very serious conversation about what their plan is. And then earlier I talked about exit strategy. It's not intuitive to think about, I'm happy, I'm getting married. Now I have to plan my divorce. Nobody wants to think that way. But in a licensing situation, you really need to think about all of the fun and excitement of the marriage and the honeymoon, but you need to think about the divorce, because it's either going to happen naturally as a result of the license agreement term expiring, or you're going to get into a fight and somebody's moving out. All right? The reason you need to do that up front is because in a reactive mode, you are making sure that you have gained up front all of the requirements that you need to regain control of your intellectual property, and at what point. Again, that could be based on failure to meet the contract requirements, breach, warranty, payment concerns, milestones, all those things we talked about earlier, again, or simply natural termination. You've gone through the end, you really don't see a reason to continue it, or it may be that the patent has expired. That's a reason to potentially exit a licensing deal. There is also consideration for change in control. You sign up with company A, who you thought could do certain things. Company B comes along and buys them out. You don't know who they are. You don't know what they're going to do with your intellectual property. You don't want to automatically allow assignment from one company to the next. That's considered a change in control. You want to stay partnered with who you signed up for. You're not going to do a marriage swap in the middle. You married one company, you want to stick through that marriage until you've reached a divorce. There's not an automatic or assignment swap of partners. I don't know what you guys do in your personal lives, but contractually that's not what you want to do. Okay. Yeah, prenups, there you go. Essentially, this is your prenup. Think about also what happens. So maybe things have gone great, maybe they haven't, but the product is out there. There's product in manufacture, there's product on store shelves, there's product in warehouses and in inventories. What's going to happen to all of that? Consider tails or options. Do you allow them a certain period of time to get rid of whatever's left on the shelf? Do you give them ample time or consideration for what's already in manufacture? If you don't, what's going to happen? They're not selling that stuff. You're not getting money for it. It's going into a dumpster? Probably not. I'm sure the stuff is still going to move off the shelf somehow. You're just not going to get the benefit of those dollars. So you want to kind of think about how you want to consider the discharge of that inventory that the licensor may have in process. And that includes all of the pieces of the marketing and other areas of your intellectual property. So again, we're not talking about one area of your intellectual property. We're talking about all areas. So if they have marketing, if they have websites, if they have collateral, all these things out there, they all kind of go together, okay? So to get prepared, start thinking about, again, your product, all of the product potential. Think about the razor blade model. That's probably one of the easiest and most well-used example of product opportunities. So you've got the razor and you got the razor blades. How many times do you just only buy a handle with no blades? Never, right? Okay. So you've got the razor, you've got the blade. You've got multiple types of blades. You can bundle them with the razor, 1 blade, razor 5 blades, razor 3 blades, razor with shaving cream, all of those things. Those are all the things I want you to think about when you think about your product. What are all the opportunities that you have for the product and its product options? And any accessories. Then think about the market, the opportunities, where it's likely to be sold, and how it's likely to be sold. Think about how you want to license it, whether you're going to go exclusive or non-exclusive. Think about the carve-outs. Think about the scope of how they're going to use the license. Think about how you're going to get paid, what each party's obligations are throughout the term of the license agreement. Think about your divorce. And overall, think about your entire license portfolio. To do that, there's a big component of this. Now that you know everything about what you think you want to do, what you think you can do with your product, you really need to understand how this fits in with the licensee. Okay? So who are they? How does this product, how does your intellectual property fit with their current products? How do they currently sell their products? How do they currently distribute their products? How do they currently manufacture their products? How does this fit? When or how long is it going to take them to get this thing to market so that you can monetize your intellectual property? And how are they going to do that for you? Right? If these things don't fit, you have some questions and concerns about how are they going to make it fit. Because if it's a square hole round peg situation, you need to reconsider the deal. You want to make sure that there's a solid fit, because in the end it's going to create a solid licensing relationship. And you want to make sure that they've done this before and that they haven't had problems and litigation as a result of a licensing deal. And if they're not willing to answer these questions, red flags and warnings, okay? They should be open to discussing all of these things with you. In a licensing situation, you're not the one coming to the table and selling them. It's a two-way street. They need to be as much selling you on what they can do for you as much as what you think your intellectual property contribute to what they will do. Again, if they don't answer these questions for you, then we may have some big issues and things to consider. So in general, licensing should be looked at very carefully. It's not necessarily a one-size-fits-all approach. Think about how it works for you. Think about how it works for your licensee, and think about how it works for both of you together, and come up with a plan that works and a plan that fits. And above all, is going to maximize your intellectual property potential and maximize your revenue opportunities. Okay?
First of all, thank you. That's